Please rise. The Justice of the Appellate Division, Supreme Court, First Department. All persons having business at the Appellate Division draw near to the attendance and shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have about 3.5 hours of argument time requested today. Therefore, I ask you to only ask for the time that you need, not the time that you want, with the understanding that we have carefully read all of the briefs and the records on appeal and are familiar with these matters. People versus Blanco. Appellant? Okay, that is submitted. Izali versus Garde. Appellant?
Alamos for appellant would like 12 minutes, 10, and then 2 for rebuttal.
I'm sorry, I'm not following you. 12 and 10?
No, 10 minutes.
Oh, I see what you're saying.
And then reserving 2 for rebuttal.
Are you respondent?
He's my colleague.
Okay, is respondent here?
We'd ask for 10, John Albany. We'd ask for 10 minutes.
6 and 1 and 6. SJ Children is submitted. People versus Malav. Appellant?
Your Honor, Sean Nuttall from the Office of the Appellate Defender. With me is Ms. Shirley Lavarco. Ms. Lavarco started on this case when she was a student at NYU Law School. She's now appearing pro hoc vice, but asked the court's permission for her to participate in this appeal.
Permission is granted. And congratulations on graduating.
We're requesting 6 and 2. Responder requests 6, please.
6, 1, and 6. North Hudson Realty versus ECAP Corp. Appellant? Are you respondent? Okay. Bangladesh Bank versus Rizal Commercial?
Jesse Law Firm, on behalf of Bangladesh Bank. Do 6 and 4, given that I'll be proposing a cross appeal as well.
Dan Perry for Bloomberry. With me is Mr. Howley, who represents a different defendant in the case. The Bloomberry, we're going to take all of the time, so there's not a splitting issue on our side, 2 different defendants. And we would request, we think we need 6 minutes.
So you're going to do all of the defendants?
I will do the Bloomberry defendants, so if the court has questions for Mr. Howley's client, I invite him to take the podium. I'm prepared to do our client. He's prepared to do his, but he's ceding his time to
I'm not totally understanding that, meaning if we have questions for him, we should call him up?
Yes, Your Honor.
I waived my time, Your Honor. I'll rest on my briefs.
Okay, so just, and you're not a cross appellant, you're just opposing?
We're just opposing.
Okay, 7, 1, and 7. People versus Rosario? Appellant? Okay, that is submitted. Greengate versus Houston? Appellant?
Courtney Scott from Trustor LLP, and with me is pro hoc vice counsel Benjamin Sasse from Tucker Ellis. I'd like to introduce him and request that he be permitted to argue.
Okay, is there anyone here in opposition to the motion? To the appeal?
Yes, Your Honor.
I'm sorry, what was your time?
Appellant requests 6 and 1.
Okay, and your request is granted.
Oh, I have no opposition to the pro hoc issue.
No, I know.
Yes,
I'm just asking what time you need.
I'll ask for 6 minutes.
Okay, 6, 1, and 6. ERA Capital versus Solel, appellant?
For the appellant and cross assignment 4 and 4 because of the cost.
Respondent?
My name is Nicole Bliss. I'm with Richie Stafford, and with me is Brian Yates, admitted pro hoc vice. We request permission for Mr. Yates to be able to participate.
So granted.
Thank you, Your Honor. We would ask 8 minutes.
Okay, I'm going to give, well, you're also, do you want rebuttal time because you also have a cross appeal?
Then we would ask for 6 and 2.
Okay, you know what, I'm going to give you both 6 and 1. And if we have more questions, we'll obviously keep asking them. Villanova versus JT Magan is submitted. Ada versus Ader is submitted. And SOS Capital versus Recycling Paper is submitted. The first case on today is Azale versus Garde.
Step up.
Permission is granted.
Good afternoon. I'm Alan Lewis for Samuel Isley. I'd like to emphasize 6 reasons why his defamation complaint should be reinstated. First, in its pleading of gross irresponsibility, our complaint is unusual in its depth, its specificity of facts, and its pleading of more than one legally recognized form of gross irresponsibility. To say the complaint devotes 14 full paragraphs to pleading gross irresponsibility, the proposed amended complaint devotes 49 paragraphs to gross irresponsibility, and to say that neither the complaint nor the proposed amended complaint satisfy what the Court of Appeals calls our minimal standard of notice pleading is simply not faithful to our state's notice pleading jurisprudence.
Well, you're talking about notice pleading, but it's a pretty high standard to make out gross irresponsibility in terms of what's required. It's a pretty deferential standard to the publisher. So why do you think you're satisfied in this manner?
Well, the complaint pleads gross irresponsibility.
It's not just enough to say it. You have to show in the actions and the way it was reported. What about the way this was reported and the way this was investigated was grossly irresponsible?
So the complaint pleads several ways in which both the investigation was marked by gross irresponsibility and the publication itself was marked by gross irresponsibility. And the
Well, I know
complaint,
one of the main arguments or that you were making was about that it didn't make clear enough that he was a paraplegic, but it does seem that there was some evidence that he does have some movement, and that he admitted that he was able to use an iPad and a device to send text messages.
well, the reasons to doubt that Isley embedded videos into emails based on his physical condition is just one of several reasons or ways in which the complaint pleads gross irresponsibility.
No,
So
it
I'd
was
like
one of the
to
main
tell
ones
you
you
what the
focused on,
others
though,
are,
which is why I brought it up.
starting with the failure to access readily accessible information. This court and others have repeatedly said that that's a basis for proving gross irresponsibility. So here, Garda, the reporter, says Burke told him that she chronicled Isley's misconduct and that this misconduct allegedly included sending her about 500 pornographic videos attached to emails. But the article reports that Burke showed Garda what she had chronicled, which was a single hooker joke and a single dirty pic.
Are
Now,
you
this
saying she
leaves...
was required to save all of her emails to show him in order for his article not to be grossly negligent?
Not quite, but what she said that he did, he sent me 500 pornographic videos. I chronicled his misconduct. Oh, let me see what you chronicled. And she has a hooker joke and a dirty pic. What that does is it raises 2 possibilities. Either Garda failed to ask Burke for corroboration or chronicling of the videos, which is grossly irresponsible, or Garda asked, but she didn't chronicle or save anything about the videos, even though she saved and chronicled the bit about the hooker joke.
So, counsel, show us a case in which the Court of Appeals of the State of New York or the United States Supreme Court or any court who is looking at this said that the reporter has to look at every single possible piece of information that is available to the reporter.
That's not the law, that's not my
Right.
argument.
Well, that's just what you said. There were 500. She should have showed him 500, correct?
No, the reporter didn't see one. It didn't make sense that this allegation was true, given that she said he chronicled his misconduct, but what she chronicled consisted of exceptionally minor misconduct. What makes more sense, who, when making and saving a record of misconduct, does that for a single
So
joke.
you're saying it was okay for him to send those two things? That make, because they're not, you know, I don't know.
I don't believe we would be here with a defamation complaint if all that the article said was he told a joke and sent one inappropriate picture. Those are really minor allegations. His reputation was destroyed by the false contention that he said he's not a disseminator of pornography. And the complaint.
Counsel, in terms of what is required, we can agree that it's not exhaustive research or painstaking judgments. And there were other things that corroborated the story from other employees, right? There are about 5 other employees that
That's wrong in 2 ways. One, when Garda came into Orbamed, first of all, he didn't confront either Isley or Orbamed with Burke's name. He didn't say, Burke told me this, Isley, what do you say about her? Orbamed, what do you say about her contention? She reported this to you. You can look at the transcript and Burke's name is not in there. Second of all, what they said to him was that nobody has ever made a complaint about Isley purportedly sexually harassing anyone. And so
But wait, what about the 5 other women who came forward and said he did this to
if you
us?
read the article, it says essentially nothing about what they said. It's all extraordinarily vague, just sort of generic, misconduct. They felt uncomfortable. They felt there to be pretty. Not one of them, the article doesn't attribute to any one of them a statement that Isley sent them pornography, that they saw pornography, that Burke told them, that Isley sent her pornography. Garda didn't ask Orbamed, who was very cooperative, gee, do you have any of this on your server?
Okay, you have
We've pled
time.
all of this.
You'll have
This
time
is
for
enough
rebuttal.
to plead
Thank
gross
you.
irresponsibility. Thank you.
May it please the court, my name's John Albano. Excuse me. I would respectfully submit that this case is quite similar to the court's recent decision in Schumann, which also involved an article reporting on sexual misconduct, allegations of rape, and sexual harassment.
Was the reporter required to request every single email that is alleged?
No, there's no authority for that. And if I may, there's a bit of confusion, I would suggest, on that point. What the article says is that dismayed, Burke began chronicling Isley's behavior by sending notes to herself on her personal email account. And then she showed him some of them. This is getting confused.
If I may, can I just pause right there? Because the reporter actually reviewed at least 10 of those emails, correct?
Yes, 10 of those contemporaneous emails shared with Stat. These are notes to herself. Separate and apart from that are the emails that Ms. Burke said she received from Mr. Isley. Those would have been on Orbamed email account, where in 2017, when the article is being reported, she's been gone for 7 years.
So the article does, to get to the point about disability, so the article does say that the plaintiff is disabled, but it doesn't indicate the extent of his disability. How is that not an irresponsible omission?
I think the answer to that, Your Honor, as Judge Swain found, but I would submit it's correct as a matter of law. If the plaintiff could plead sufficiently that it actually was physically impossible for the plaintiff to have done what 5 sources said he did, 4 women who said they left the firm because of his boorish behavior, Ms. Burke, and if I may, I am trying to answer that question. Ms. Burke, this I would suggest is significant. The plaintiff admits that Ms. Burke told Gard what he reported. He has to admit it. He sued her for saying it. She is sued in this case for making the statements that Gard said she made. Now, to address your question more directly, Your Honor, I would understand a claim that said, it's physically impossible for me to have done these things, and so you should have done more. But none of these accusations were physically impossible.
Was the plaintiff, and the plaintiff was given the opportunity to respond, correct? And his response was in the article, correct?
Yes, his denials were
So he clearly
prominently.
could have said, I could not have done this.
And a 90-minute interview, all we've heard in this case is it's physically impossible. A 90-minute interview, nobody says, hey, by the way, this is all physically impossible. Couldn't have been done. It's not grossly irresponsible for a reporter to sit through a 90-minute interview, have 5 additional sources that he relies on. I should add, a 6th source who corroborated that Ms. Burke had told her about these events and how troubled she was by them. But it is not grossly irresponsible for a reporter to say, I sat through a 90-minute interview, nobody told me that this was physically impossible. He had an iPad brought into him. He said he could use a fork, and he says he uses assistants to send electronic messages. He says that's what he used Ms. Burke for, among other things, from 2009 to 2010. So there is nothing physically impossible about the allegations that were made against Mr. Isley. Unless there are further questions, I think I've covered what I intended.
Thank you very much.
Thank you.
Briefly address Schuman. That is a very different case because while the general rule is that gross irresponsibility requires discovery, this court held that in Goldreyer, which is on page 9 of our brief. The facts in Schuman were a very far cry from this case. To explain its conclusion that the reporter had no reason to doubt the information provided, the court explained that, among other things, the reporter asked its source for and obtained from her source evidence in many forms, including text messages, documents from various litigation, Title IX documents. That's in stark contrast to here, where Garda had many reasons to doubt Burke's accusation.
So, but it's not rather, it's what did he do, right? So he interviews her, he looks at the text that or some information that she sends him that corroborates.
It doesn't corroborate, and what's not there is what's really so important, because if she rationally sent notes to herself about what most disturbed her, but she didn't apparently send a note to herself about receiving these emails. That creates doubt.
With the corroboration, but it does corroborate her allegations. Then he speaks to 5 other people who also corroborate.
None of them corroborate this notion that Isley sent pornography, which is what is so damaging. That's what required more investigation. To Justice Friedman's point.
No. Your time's up. I was just letting you answer that question.
Thank you.
Thank you very much. The next case is People versus Malov.
Good afternoon, and may it please the court. Shirley Lavarco, appearing pro hoc vice under the supervision of the Office of the Appellate Defender. I represent Miguel Malave. Sometimes, when people run from the police, it's not because they're guilty, it's because they're afraid. And this is especially true for people of color like Mr. Malave. But the jury in his case was expressly forbidden from even considering that possibility. For that reason, as well as for the insufficiency of evidence on the valuation element, this court should vacate his conviction.
Was this argument raised below?
I'm sorry?
Was this argument raised below? Was it preserved?
The issue is preserved as the court ruled on the issue by expressly instructing the jury to disregard any relevance to race, and because the defense counsel made his position clear. But even if you disagree that it's unpreserved, that doesn't prevent you from ruling on the issue in the interest of justice. And I think it's important that you do, given that this was that the flight evidence was a central pillar of the prosecution's case.
Counsel, in this particular case, the defendant did not testify, is that correct?
That's correct.
But in summations, the defense counsel was allowed to argue that point, that the person who held him there was white, and maybe there was some racial undertone there, right? So there was some argument put forth.
Yes, that's right. There was some argument put forth, and with every attempt of defense counsel to argue this, nearly every attempt, the trial judge shut it down on something like 9 occasions and then gave an express instruction to disregard it. So I just want to point out that in the moments leading up to Mr. Malave's arrest, just what the scene was that defense counsel was trying to draw attention to. There was an older white man impersonating a detective and physically blocking his path.
What evidence was there that this was based on race in any way? That the response he took was based on a racial issue? What evidence was presented at trial other than your conjecture after the fact that that's what occurred?
Defense counsel was permitted to argue an alternate inference to draw from the fact of flight. So the evidence put forth by the prosecution was that Mr. Malave ran when he was confronted by...
What actual evidence in the record supported that he was running because of a race issue versus he was running because they caught him, you know, with a motorcycle he was not supposed to have?
The only affirmative evidence of that could have been if Mr. Malave himself had testified and said that, and I don't believe that Mr. Malave should have had to trade his Fifth Amendment right for his Sixth Amendment right to rebut the prosecution's theory that he ran because he was guilty. He's entitled to the benefit of any innocent explanation of his flight, and he was denied that over and over again, and it greatly prejudiced him. Counsel was just acting in accordance with best practices, encouraging the jury to put themselves in the shoes of a young Hispanic man who, again, was confronted with someone who was impersonating a police officer, several actual armed police officers running towards him, and a crowd of 20 to 40 people that was forming around him. So I don't think that expert testimony or Mr. Malave's testimony was needed to at least suggest to the jury that they should be permitted to consider race as an explanation for the flight, which is supposed to be only slight evidence of guilty knowledge.
And counsel, I just want, that charge was given to the jury, right? About evidence of flight?
Yes, that's correct.
Okay. So it's not like the jury didn't know that whatever evidence there was with respect to that evidence of flight, it wasn't supposed to be taken by them as the linchpin in the case.
That's correct that the court gave the correct instruction, but the prosecution portrayed the flight as tantamount to guilt over and over again, and the jury was specifically instructed that it could not consider this particular inference that he ran because he was afraid as a young Hispanic man confronted with these dynamics and armed people. If I may, if there aren't questions on this point, I'd like to briefly address the valuation element. So the evidence was legally insufficient to prove that the value of the motorcycle exceeded $3,000 at the time that Mr. Malave actually possessed it, which was 18 days after it was stolen and after it had sustained significant damage. And nowhere in its brief does respondent actually suggest that the prosecution presented any evidence of the value on September 26th, the day that he had it. The expert specifically said, I'm doing this based off the VIN number alone. I did not see the motorcycle. I'm not aware of any special circumstances that would change its value. And he gave no indication he knew anything about the damaged condition that it was in. And this court has vacated conviction.
So let me ask you this, counsel. Was this issue, the sufficiency of the value, raised below?
Unfortunately, defense counsel conceded the issue below, but I think that's why it's even more important that this court take it up, because the jury was told that this is entirely uncontested.
And there was an expert who testified with respect to that, and your client's attorney had the opportunity to cross-examine him about all the things that you are raising right now, correct?
Yes, that's correct.
So,
counsel should not have conceded it, but this is an essential element of the crime.
Well, the expert said it did meet the test, and you're challenging that testimony, as did his attorney below, right?
The expert said it met the test without knowledge of the motorcycle's condition, so only
So again, on cross-examination, that's what the attorney for the defendant argued to, or raised with him, right?
I'm sorry, so are you asking me whether the attorney conceded the issue?
I'm asking you whether the attorney below cross-examined the expert.
Yes, the attorney below cross-examined the expert.
Okay.
Thank you. You have time to rebut.
Thank you. Good afternoon, may it please the court. Megan McLaughlin for the people. Now, to start off, both of counsel's
Getting
arguments.
to the valuation issue, Detective Burke testified that the value was $5,570, right?
That would have been at the time of market value at the time that defendant possessed it, yes.
At the time of what?
Defendant possessed the motorcycle, which would have been approximately 3 weeks after it was stolen.
At which point it had been worth $67.80.
When the victim first
Knew it was
purchased-
the victim paid $67.80 for it.
Yes. And then at the market value that would have accounted for depreciation would have been that lower 5,570
Which
number.
still takes it well above the 3,000 threshold.
Yes, Your Honor, well above the threshold. And
what about the damage that there had been to the motorcycle, to the gas cap, to the ignition, to some side panels? How is that accounted for in all of this?
yes, Your Honor, the expert did not specifically testify about the specific damage. However, the jury was shown photos of the motorcycle both before it was stolen and after it was in the possession of defendant. And those photos were, the jury was able to observe those photos and then received an instruction from the court which said you should calculate the value of the motorcycle as it was when defendant possessed it. So the jury had every reason to have correctly followed that instruction and evaluated the value of, or at least used the value that would have been in the possession. It's also important to note that
So is there any testimony as to what the value was at the time that the motorcycle is found in view of the damage which had been done to it?
Not with that specific damage. In terms of the expert, the photos did include the damage which were shown to the jury, and the jury did use those and ultimately.
How is the jury to evaluate what that does to the 5570 estimate?
The jury did not receive any expert guidance on that. However, this court has found that an original cost, in addition to a market value cost, can be used by a jury to estimate the value of the motorcycle while it was in a defendant's possession without actually having a solid number given to them by an expert.
I mean, is there also, is that a permissible path here, that there's an inference, clearly a clear inference, that the defendant is one who took the motorcycle, and at the time he took it, it had a value of, in and about, how many days after the victim had, it's like 10 days or something.
It was approximately 3 weeks after
A very short period of time that it was worth $67.80.
Yes. So yes, while there was no proof at trial that defendant is actually the person who stole the motorcycle, its condition while defendant was in possession of it was operable. The only modifications to the motorcycle that had been made at the time defendant possessed it were modifications that would have allowed somebody to use it in an unauthorized manner. So it was only actually after it was returned to the victim that it was quote unquote inoperable. Even the defense attorney below during his closing argument, in arguing that defendant didn't know the motorcycle was stolen, pointed out that there was so little damage to the motorcycle. How could somebody have known that it was stolen? Obviously, those facts were proven.
Counsel, if I may, the defense counsel below only argued that the case should be dismissed because there was no evidence regarding defendant's knowledge that the vehicle was stolen, correct?
Yes, Your Honor.
And in summation, defense counsel actually said, as far as the third piece of the puzzle, that the property would have to be worth more than $3,000, and that the detective indicated that the value was approximately $5,000. The people have that piece of the puzzle.
Exactly, Your Honor. And that concession actually deprived the people and the court of the opportunity to clarify or provide further proof, as the proof that the people had already presented was sufficient.
And I just want to, just one more, and the complainant showed a receipt showing the purchase of $67.80 and indicating that he really only used it a few times a week.
Yes, Your Honor.
All right, thank you.
Of course, if this court has any other questions regarding the defense claim, I'm happy to address any of those questions. Just very quickly, the defendant was absolutely given the full opportunity to present a defense. The defendant did present the defense that
Nor did the defendant raise below that he was denied an opportunity to present, that his constitutional right to provide a defense was impaired.
No, Your Honor. The defendant made certain arguments.
It's an unpreserved issue.
Yes, Your Honor. And I would just like to point out that when the court did admonish the counsel for making a race-related argument, that was in the context of the credibility argument of the witness that witnessed the defendant with the motorcycle. That was not as to the quote-unquote flight arguments that on appeal, defendant claims that counsel had been making. However, those claims were not, that position was not explained to the court after the objections were sustained. Counsel would just move on. So those were, it's the people's position that this claim is not preserved at all. But in any event, defendant was given the full opportunity to present the defense that his flight was caused by innocent reasons other than guilt. If there are no further questions, I will rest on my right. Thank you. I'd like to just address a couple of things briefly. First, I just want to underscore that the expert's testimony, again, respondent just conceded, did not account for the damage. They're relying solely on the photos of the motorcycle and presuming that the jury is able to make an accurate estimate of by how much the damage depreciated the value. The expert took only into account the depreciation between the purchase price, the motorcycle was purchased in the summer, and how much it would have depreciated off the lot, but it did not take into account, and I find,
Was that issue preserved?
Was the issue
Was
preserved?
that issue preserved?
The issue is not preserved, but this does not prevent the court from ruling on it, and I think, again, it makes it only the more important that the court perform its duty to sit as a 13th juror and decide whether or not all of the elements have been proven beyond a reasonable doubt. And if the defense counsel, unfortunately, was telling the jury that this issue is uncontested and does not matter, and the prosecution is saying the same thing, then I can't think that they were scrutinizing the photos to say, how much should we deduct for lights? How much should we deduct for the seat? How much do we deduct for the body panels?
Thank you, counsel.
Thank you.
North Hudson Realty.
May it please the court, Your Honor, Oscar Michelin for respondent. Appellant having submitted, I just took a minute in case there were questions from the bench. And if not, we'll rely on our brief.
Any questions? Okay, thank you.
Thank you for your time, Your Honor.
The next case is Bangladesh Bank versus Rizal Commercial.
Good afternoon, may it please the court. My name is Jesse Loeffler of Cozen O'Connor on behalf of Bangladesh Bank. We are the appellant on two issues, personal jurisdiction over Solaire Casino and dismissal of Eastern Hawaii Leisure, which I'll refer to as EHL, on forum nonconvenience grounds. We're appellees on EHL's personal jurisdiction and a service-related issue. I'll start with the Solaire personal jurisdiction issue. This case involves a vast international conspiracy to steal $100 million out of the New York Federal Reserve Bank, just down the street from here. This was a brazen attack. They tried to steal $1 billion, only got $100 million, spirited it out of the country through correspondent banking accounts, also in New York and Philadelphia, held by a party that's in the case right now before Judge Maisley, Rizal Commercial Banking Corporation.
I know it's a very complicated transaction. We are familiar with it, but why don't you focus, since we're talking about personal jurisdiction, what that defendant's contacts were or activity in New York that would support asserting in personam jurisdiction.
So we moved under several theories of jurisdiction. The first and foremost was conspiracy jurisdiction under 302A2. And New York law allows you to essentially use the New York conduct of co-conspirators to bring in out-of-state defendants. And that's what we allege happened here.
What are specifically the allegations having to do with their awareness of the origination of the laundering occurring in New York as opposed to the various events which occurred in the Philippines?
Sure. So to hear Solaire tell it, they'll say, oh, we're the passive recipients of funds after the theft. We're step 5 in the transaction. We don't allege that. We allege they were involved with step 1, the creation of these fictitious accounts into which the money was sent in US dollars, despite the fact that Solaire does not have US dollar tables for gambling. And we allege that essentially...
How can you support anything that happened at the casino as evidence that they were involved in the original conspiracy in New York to initially remove these funds?
Because those facts occurred in time before the theft itself happened. These fictitious accounts were created in May 2015, and the hacking and the moving into the Swift Live server didn't occur till between January 29, 2016 and February 4th, 2016.
The fact that they might have been involved in laundering these funds in the Philippines, how does that connect back to the creation of this? What involvement did they have in creating these fictitious accounts or being involved in these fictitious accounts, any of those events that allegedly took place in New York?
We think it's tied to the theft because they needed these fictitious accounts before the laundering ever happened to get the funds, the stolen funds.
What did they have to do with the creation of the fictitious accounts? I guess
So
that's what I'm asking.
right. We allege that Kim Wong, Maya DeGito of RCBC met in a back room at Solaire Casino to create these accounts. Whether there were other Solaire employees or who gave them access to the room, whether they had CCTV.
So they met in the Philippines.
They met in the Philippines.
Met in the Philippines. Okay.
That's correct.
So So 302A what? If they're meeting in the Philippines, they're planning in the Philippines, where does that give you jurisdiction under 302?
302A2.
A2. So the tort occurs, the conspiracy occurs in the Philippines.
The tort occurs in America with the
How does
theft
the
of
tort,
$100 million.
if the conspiracy is hatched and planned out in the Philippines, how does it occur in New York?
We're not alleging that the conspiracy all of it was hatched in the
Well, what are you alleging? Where were they in New York when they conspired, right? 302A2 is a tortious act in New York. So what tortious act did they do in New York?
We cite a few cases that say...
Let's assume that we agree. Let's assume that we believe that 302A2 requires activity in New York. What have you alleged they did in New York to sustain jurisdiction under 302A2?
They're co-conspirators.
Not their co-conspirators, them. What did they do? A tortious act by an individual. Is there anything in the complaint that says that any of them did a tortious act in New York while they were in New York?
Anyone from Solaire, the answer is no.
Okay.
But we don't
Even
believe
that
you
they
need
had
that.
knowledge. Let's say they didn't do any of the acts, but you're saying they're part of that conspiracy. So what knowledge, what do you allege other than information and belief as to any knowledge they had about anything that happened prior to them receiving the funds in the Philippines?
I think this is one of our principal arguments about...
Because you do make that allegation about the other defendant. You make the allegation about Wong, but where's the equivalent allegation?
So I think it's a matter of drawing inferences, and this is what we kind of talked about in our briefs, is on a motion to dismiss, the inferences are supposed to be drawn in the non-movement's favor. And there were a lot of facts that we allege that we think demonstrate an inference of knowledge by Solaire. For example, the setting up of these accounts. The only people that could have given
Those
that
accounts
account
are set up in the Philippines.
in the Philippines, the hackers were North Korea, China. They hacked into Bangladesh. This isn't all in the Philippines, right? And so we have them.
Right, but we're focusing on New York, and we have to have something that supports a New York court asserting impersonum of jurisdiction. It has to be some knowledge on their part of activities taking place in New York to support the jurisdiction.
That's the inference we think should be drawn.
So is the inference that you're looking to have us draw, and the fact that I'm stating for it doesn't mean that I'm agreeing with it, but the inference that you're looking for us to draw is, look, there's this $80 million which is siphoned off from the Federal Reserve into Rizal Bank in New York, and at the end of the day, we see that all of this money ends up in these other parties and entities' hands in the Philippines. This didn't just happen. $80 million doesn't just move from New York out into these accounts in the Philippines unless something's gone on between all of these parties. And at the pleading stage, it is fair for us to say you should draw an inference that they're involved in part and parcel of this whole endeavor that took place, but starting by taking the money out in New York.
That's exactly right.
And what could we base that inference on? What could we, literally, a conspiracy, I mean, you have to have some real facts.
And I think we do.
Tell me what.
So we have the setup of the accounts. We
Okay,
have
the setup of the account, okay.
We have-
Assuming after that,
right. So then we have a bunch of allegations in 326 and 327 of the complaint about all the red flags that surrounded this cash
In
coming
New
into
York.
junket. No, that's not in New York.
again.
The hacking is into New York.
Again, it has to connect to New York.
The conspiracy connects
I
to New
could
York.
know about a conspiracy that happens in China. That doesn't mean that I am subject to New York jurisdiction.
The conspiracy jurisdiction theory is you can impute the co-conspirator that reached into New York, the hackers, to all the other defendants if you tie them together with specific allegations and inferences, which I believe we do. If you look at 326 and 327, I'll just reserve my remaining time unless there's other questions.
Thank you.
Good afternoon, Your Honor. Dan Perry from Millbank on behalf of Defendant Bloomberry. As we established, Bloomberry does business only in the Philippines. It's a Philippine casino.
Isn't it asking us, and I'm just asking, isn't it asking us to take quite a trip to say, well, this money moved out of the Federal Reserve into Rizal Bank and then travels from Rizal Bank through all of these other areas and banks and accounts, and all of this is happening. And all of these entities in the Philippines, they didn't know anything about the fact that this $80 million was being siphoned off at the Federal Reserve. We're supposed to believe that that's got nothing to do, everything else that happened later on just happened.
So let me answer the question directly as to my client. I think this case presents interesting issues in line drawing and where one draws the line on conspiracies where the money laundering takes place abroad, which I think is what your question's driving at. As to my client, there's really no logical explanation why North Korean hackers who perpetrated a theft here at the behest of Kim Jong-un, that's alleged, and I believe that to be true, would steal funds from plaintiff's account here only to divert them to the Philippines at the behest of a Philippine casino to have Chinese gamblers gamble in their casino. It simply makes no sense. What makes more sense is that money is fungible and someone in China or involved with the theft directed money to the Philippines where it was played in not just Solaire, but I think there's an allegation of 3 other casinos. It's not $80 million that goes into Solaire, it's roughly 30. And also the business of
Certainly you're
Solaire.
not telling us that the leader of North Korea siphoned money out of the Federal Reserve in order for some gamblers to have a good time in the Philippines.
You're absolutely right. It makes no sense, but you have to believe that. You have to make that inference in order to conclude that there was knowing participation by a Philippine casino in a theft by North Korean hackers in New York. If you can't make that connection, if you can't make that inference, then you can't establish knowing participation under our law of conspiracy. It's just a step too far.
So basically, even if they were aware that there was some conspiracy going on, they weren't aware of anything happening in New York for us to have jurisdiction at this point.
Yeah, we would obviously contest that they were
Obviously.
aware, right? But as I apply the test of knowing participation, as the courts in New York have articulated it, I have to knowingly participate in the theft in New York in order to be hailed into a New York court on a conspiracy.
And let me just ask you, so these plaintiffs have the ability to sue your client in the Philippines, correct?
They do. They have a cause of action, and most of the...
And that's where all the stuff is happening, in the Philippines, not in New York.
Yeah,
The only thing that's happening in New York is transfers from bank accounts, correct?
Yeah, they have two ways to recover here. In New York, they've sued, and Justice Maisley has determined she has jurisdiction over RCBC, Resolve, a bank with the accounts here. So they have a 80, 90, $100 million claim that will go forward against a big international bank in New York.
This is going to result in litigation being split up, though. Some of the litigation would take place in the Philippines and some would take place here if we affirm the finding that there's no jurisdiction.
That's right, Your Honor. And this bleeds a little...
Does that at all support the argument that it really is one big conspiracy and that it all should be heard together in one place?
I don't think so, because really the gravamen of what they're saying with respect to my client is you effectively negligently supervise the activities within your casino, a casino that's subject to Philippine laws, Philippine regulation, Philippine
Let me
regulators.
ask you, there were some direct allegations about Wang, which I realize is not who you're representing. I'm not sure why he's not arguing. But there is some allegations about at least one of the casinos being involved in the underlying conspiracy. Does that help support an inference that maybe there's something more as to all the casinos?
I don't think so.
You keep saying the casinos are separate, they have nothing to do with it, but at least one of the casinos is some concrete evidence of a greater involvement.
I think Wang has a casino in the Philippines. It has nothing to do
Wang
with
is the
us.
principal of EHL, isn't he?
Eastern Hawaii, he is.
Yes, and isn't Wang also friendly with Tran? With someone by the name of Tran, the main player at Rizal Bank?
Those are the allegations that, and
But
remember...
we're talking about pleading now, aren't we? I mean...
But Wang's not our guy. Wang is... Solaire is a casino. It doesn't employ Wang. Wang is not its agent. And Wang, by the way, as I understand Justice...
Who owns Solaire? Who owns Solaire?
Solaire is owned by... it's a publicly traded company in the Philippines. The majority of the owner is Enrique Rizon, who's one of the 3 richest people in the Philippines. It's like, I think, the only 5-star hotel in the Philippines. It's not sort of a back office type place where you would expect, dark rooms. It's not that. And just coming back to your question on the conduct in the Philippines, all of the witnesses for my client are Filipino, would be from the Philippines, all of the documents,
This
all
is
of the
not so much
evidence.
really a matter of where witnesses are. We're dealing here with a lot of electronic transfers, which the Federal Reserve is involved in this case, are they not? And haven't they agreed to assist Bangladesh Bank in pursuing this case? It's not really a witness case. This is going to be a case which is going to be tried by trying to unravel electronic transmissions.
For the banks, yes. For the casinos, because the gist of what you've
Money
heard...
into their accounts and into the casino. It's once you get into the casino, and maybe what happened with the pesos into which the funds were converted, yes, then there may be some. But until you get to that point, this is all about electronic transfers and unraveling what's gone on.
I totally agree with that, but as the case as to my client is really sort of a negligence case about insufficiently surveilling Chinese gamblers at the property. That's a claim that ought to be heard in the Philippines because it arises under Philippine law, involves Philippine people. And so that's both a forum non-point, but it's also a jurisdictional point. This is, as to my client, a Philippines-based case.
Thank you.
Thank you, Your Honors.
I would make a few quick points. First, going to the knowledge piece. We allege that as of February 29th, there is public reporting all over the Philippines that the money, stolen money, is being gambled at Solaire by a junket operator.
Well, let me ask you, what does that have to do, again, I know we're repeating ourselves, with New York? The fact that it's stolen money, that it's been transferred from somewhere else. What does that have to do with that it was transferred from a bank in New York? How would the fact that they know or have some knowledge that the money was stolen mean that they know the money was stolen from, and isn't it, don't you actually allege the contrary? Because you go with great specificity in the complaint, how there were so many different fictitious accounts, so many ways that it was hidden, how the money was actually moved. How then would the casino in the Philippines be able to follow this and know all this and have knowledge that it came from New York initially?
Again, we allege, with all the facts that involved Solaire, we allege that inference from those facts is knowledge, including waiting 11 days after it's public knowledge that these are stolen funds to stop the gambling. They didn't change their
That just means
behavior.
they knew it was stolen funds. That doesn't mean they knew it was stolen funds from New York.
We think that's the inference of all the daisy chain of events that they were involved with. And I note, I cited Wimbledon v. Master Fund 160 AD 3D 596. That says, look, to a certain point, especially at pleading stage, acquiescence can be enough to show membership in a conspiracy and to impute knowledge. And that's
Thank
what
you.
we're... oh,
Thank you very much. The next case is Greengate versus Houston.
Good afternoon. Ben Sasse for Appellant Houston Casualty Company. Insurers are free to select their risks.
Your point is that this didn't cover this sort of it wasn't specifically named that it's Greengate's romaine lettuce that's the problem, and therefore the policy doesn't cover the situation. But how do you deal with the fact that at 5.3 of your policy, when it defines adverse publicity, it's page 88 of the record, means the reporting of an alleged accidental product contamination or malicious product tampering at any locale, region, including but not limited and provided that the publication specifically names, I've skipped what doesn't really matter, both the insured and its products. So when you wanted to require this specificity, the policy knew exactly what to say in order to make clear that you had to show that it's Greengate and it's romaine lettuce. So why shouldn't we deduce from that the provision of the policy that's an issue here, which doesn't have such language, doesn't mean you need such specificity for the plaintiff to be able to recover?
So I think that's apples and oranges, Your Honor. I think there is specificity in the government determination endorsement to the adverse publicity endorsement. That, of course, is related to communications that could be harmful to products. Here, what you're talking about, though, is a finding of reasonable probability. That's a level of confidence by the government that it has to be specifically identified product of the insured. And so I don't think you can get where they want to go without reading the word specifically out of the policy. And I don't think you can get where they want to go unless you don't read the definition of product that comes into.
What you're looking with the specifically identified product of the insured, what you're looking is that both the insured and the product have been named. That's what you find wanting in when they make this claim for the policy.
What I find wanting, Your Honor, is a reference to specifically identified Greengate lettuce, that romaine lettuce. That is lettuce that Greengate manufactured.
The policy doesn't say that. The policy doesn't say that, which it does say when you talk about adverse publicity.
The policy says you have to specifically identify lettuce Greengate handled. And so if I can back up a step,
Well, where
all right,
does
this
it
comes.
say that? It says specifically identified product. It doesn't say Greengate. It's a product. Romaine's a product.
So product, Your Honor, and the product is in bold and it's capitalized. And when you look at the definition of product, what it says is products, including adjustable products, manufactured, handled, or distributed by the insured. And so that's where I'm going.
And is that not the romaine lettuce? Romaine lettuce is handled, manufactured by the insured, which would fall in line with the April 10th, 2018 announcement from the CDC about the E. coli outbreak, right? It was specific to romaine lettuce in Yuma, where part of their, where Greengate had their plants.
So what the what the announcement said, Your Honor, is that romaine lettuce could be contaminated and that contamination could cause injury. And the difference here is the level of confidence and a specific reference to product Greengate handled. Remember that when this was marketed, and we do get into the marketing materials, or at least my friend on the other side does, what the purpose of this coverage was to fill a gap between a recall event, right? A recall where product is recalled from the marketplace, and an actual inspection of the insured's facility where Listeria monocytogenes or some other contaminant was found on some piece of equipment, and then FDA said throw out those products. That's specific to the product and the way the policy calls.
Which is not what happened here.
That's not what happened here. But my point is, the reason why it doesn't align perfectly or map perfectly with this situation is this was not a situation this was designed to cover. Can it cover it? Sure. If all of the lettuce in Yuma, Arizona was contaminated, which was never the finding. There were over 80 farms there, and the finding was only many farms, not all farms. If there was a farm that was specifically sourced to the policyholder.
So it is clear, but the CDC says, right, that it could not explain it for a single grower, harvester, processor, or distributor. Impossible to do. So all of them are in. So the choice you have as the grower is, sure, let's let people die, or we take a chance that it's not our farm because the CDC says we can't figure out specifically which farm, or pull it off the market because the CDC says specifically enough it's romaine lettuce coming out of this region, right? Which is where this plaintiff is. And the CDC says we can't drill it down any further. And your position is, under those circumstances, your policy doesn't cover this?
My position is it doesn't cover it. That's exactly right, Your Honor. And
why would anyone buy the insurance if it couldn't be covered for this event? It's illusory insurance. If the CDC says I can't drill it down any further, I know that it is in this region with these growers, what possible use would that insurance be?
with respect, Your Honor, what we explained what it was marketed for, and I alluded to it a minute ago. It's for on-site FDA inspections that identify.
Where in the language of the policy that we're talking about does it say that?
The language.
You're making it very narrow. Where's the exact language?
The language is specifically identified. What you're talking about, and reasonable property.
Just so I understand, your whole argument as to that they have to go to that plant or that farm is based on specifically identified product. That's the linchpin of the argument.
There's two parts. Specifically, well, three parts. Specifically identified, that's prong one. The definition of products, that's prong two. Reasonable probability, that's prong three. They all work together. Why do you need a reasonable probability finding? Because you have to have confidence that that product is, in fact, the product that may cause harm. What happened here on both outbreaks?
You have time for rebuttal. Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Bradley Nash of Hoge Newman, representing the plaintiff respondent Greengate. The CDC and FDA determinations at issue in this case specifically identified one of Greengate's products, its romaine lettuce, as a probable source of E. coli contamination. There's no dispute. Common sense.
It wasn't actually recalled, isn't that so?
So there was no formal recall, but there's no requirement of a formal recall. So there is a separate coverage section that applies to product recalls. By the way, their own marketing materials clarify that recall doesn't mean that the FDA has announced or the CDC has announced or has imposed a regulatory requirement that there be a recall. Recall just means that that in this case the distributor Greengate has announced that its customers should return the product in exchange for a customer credit. That's all the recall is. But there's no requirement of a recall. That was one of the
So how do you address the argument that the CDC did not specifically identify your lettuce?
There's two answers to that. So number one is that the requirement is that the product be specifically identified, not that
Meaning
Greengate,
lettuce.
right, not that Greengate by
Okay.
name be specifically identified. And there's obviously, there's evidence, as was discussed, that the insurer knows perfectly well how to require the insured to be identified by name. There's no scenario that Houston Casualty has identified where this policy would apply under their reading, where Greengate isn't identified.
No, they're
by
saying
name.
that when if the CDC came in, tested your sort of
Right.
facility and said there's E. coli here, then it would
So
apply.
that's one possibility. There is no heading, as I think one of your honors pointed out. There's no provision in this policy that says anything about site inspections. There's no evidence in the record that those kind of inspections even happen. We had an expert who submitted an unrebutted report.
Their own expert, Dr. Rachel Goarzi, said that the thing to do was to recall the lettuce, right?
Well, that's right. Everyone is in agreement. I mean, it's common sense. The CDC made an announcement. Romaine lettuce from the Yuma, Arizona growing region, the very region where Greengate was sourcing its romaine, could be contaminated with E. coli and could make people sick.
And I would imagine that if the product hadn't been pulled, we'd be here having a different conversation with them arguing, well, you didn't pull it fast enough in light of this government announcement.
Absolutely. And then in November of 2018, the FDA announces all romaine lettuce on the market should be withdrawn and destroyed. That couldn't be more clear. That obviously applies to Greengate as a processor and distributor of romaine lettuce. And there's no argument that anyone has articulated that we wouldn't have to comply. And, so with respect to their argument about site inspections, again, there's no language in the policy which says that there's a requirement as a trigger that there be some specific investigation of our facility. That would be a narrower form of coverage that they could have written, but it's not what they sold to us. And the other argument that's important, it is a bedrock principle of insurance policy interpretation that you have to read the language from the perspective of a reasonable insured in this industry. And what our expert demonstrated in her report, which was not challenged on summary judgment, is that the situation that occurred here, which is to say the CDC and FDA identified romaine lettuce, in one case, all romaine lettuce, in another, they were able to get more granular and identify a region as a source of contamination. And market participants, including Greengate, were required as a regulatory matter, as a legal matter, to withdraw their romaine. That is this typical scenario that occurs. It is a rare case. It almost never happens that these traceback analyses can identify one specific commercial source of contamination. Sometimes, as was the case here, no commercial sources can be specifically identified, but this is the scenario that a reasonable insured would anticipate. This is what actually happens in reality. The narrow coverage that they're hypothesizing after the fact in order to deny this claim is not what an insured would expect to happen.
Thank you.
Thank you.
Just to pick up where we left off, what happens in reality, according to their own expert, beginning at record page 293, is that at least 70% of the time, FDA or CDC is able to identify at least one source of the contamination. And we would not be denying coverage, of course, if they were able to identify a source that actually gave their lettuce to Greengate Farms, but that's not.
If they identified a source of a plant down the block and then said, everybody pull, you'd say there'd be no coverage?
I would say there would be no coverage unless the Greengate sourced lettuce, that is the farms that provided their products to Greengate, were found to have a reasonable probability that that lettuce would result in bodily injury, Your Honor. And here,
But I mean, isn't that what the CDC says? That there's a reasonable probability that this outbreak comes from the lettuce that's grown in the Yuma County, right?
that's not what they said, Your Honor. What they said was could be. They said could be. Could be is language of possibility, not reasonable probability.
let me.
That was the quote. If you look
Was
at my friend's
it,
brief at pages 15 through 16, they say
the
could be
outbreak-
contaminated and could result in bodily injury. That's language of possibility,
Did they
not
not
reasonable
say
probability.
romaine lettuce from the Yuma growing region was the likely source of the outbreak?
They said,
I'm reading exactly what, I think that's what I'm reading the
said
correct thing.
was the
The
reason-
likely source of the outbreak.
likely source of the
And
outbreak.
we cannot drill it down any further, right?
at that time, they did drill it down further to a canal.
Right. So at that time, their choice, the plaintiff's choice is don't believe the CDC and wait and see whether or not they actually can drill it down, and not pull, or pull and have the reasonable expectation that their insurance is going to cover because the CDC says it's likely coming from this region.
I know my time is up. May I respond?
Can I answer her question?
Thank you, Your Honor. So I'll close with this thought. This is an ancillary coverage. It is only an extra 10% premium. It's purchased for a few specific scenarios. This scenario, I'm not saying that they did anything wrong. That's not our position. I'll end where I started. Insurers are free to select their risks. This is not a risk that's covered with that small addition to a coverage for what is normally a product contamination policy. And what the record shows usually involves claims dealing with actual contaminated products. Thank you, Your Honor.
Thank you. The next case is ERA Capital versus Solel.
Good afternoon. May it please the court. David Friedman, Friedman LLC for ERA Capital LP, appellant and cross-respondent. We are appelling the court below's dismissal on summary judgment of the breach of fiduciary duty claim, and we're opposing the appeal by Regions Bank of the court below denying summary judgment on our negligence claim. ERA Capital is basically a family office. The adult son, Amir Shapira, had been running the entity since approximately 2013. He was the sole decision maker. He opened a checking account and a foreign exchange account with Regions Bank in 2015, and that was...
We're familiar with the facts. What
you.
we'd like to hear from you is why you think there's a viable fiduciary duty claim when they were just an advising bank. What would be the dominion and control sufficient in this particular case to satisfy a claim for fiduciary duty?
Thank you, Judge. So here, the activity that's underlying this lawsuit has nothing to do with the checking account or the foreign exchange account. It also has nothing to do with Regions being an advising bank. Regions was asked to be an advising bank by the issuer of the LLC Soleil, and that's a very limited responsibility. Basically, they turn over the letter of credit to the beneficiary. What we're talking about is a relationship and an agreement by Regions to advise our client, who had no experience with using letters of credit as collateral.
So what is the agreement you're referring to based on the discussions that were had between?
And written correspondence, the email.
There's no actual agreement in this case that we're going to advise you on how to deal with letter of credits.
Well, in a way there was, Judge, because my client went to his relationship manager, said, I need help with this letter of credit transaction. The manager directed my client to the head of the letter of credit department, Mr. McCorkle. My client reached out to Mr. McCorkle in writing, said, I have no experience with letters of credit.
What you have a negligent misrepresentation claim, which the court did allow to go forward. What brings this from a negligent misrepresentation to a breach of fiduciary duty, which requires something more?
I agree, it does require something more, and we believe we've met that something more by showing that my client had no experience, the bank was the expert, my client asked for guidance, the bank agreed to...
Wait, but doesn't he open an account where the account statement and agreement says, I'm not your fiduciary? Doesn't he open a SWIFT account that says, I'm not your fiduciary? So if he thought in his head that something else was going on, the documents and the agreement that he signed with the bank says exactly the opposite. So how can you possibly allege that there's a fiduciary duty when in the agreement, the only agreement that the two parties have, the bank says, I'm not your fiduciary. Let's make that clear.
Justice Scarpula, the bank raised that argument, and they're wrong because they miscite the language in the agreement. They use ellipsis to delete the language that's relevant. The agreement says, for this checking account or other related business, we are not your
And
fiduciary.
it's your contention that this relates to other business. First of all, how much did you pay, if the record reflects it, did you pay for this service that Regions was going to give you on checking on the letter of credit?
$0.
So you're saying
we cited,
there's a fiduciary relationship except that the agreements you signed disclaim it, and you paid nothing for it. So what have you got to show that there was as opposed to a negligent misrepresentation,
Right.
what if you have to show that that both sides agree to a higher standard of care?
okay, the agreement does not say that this relationship is not fiduciary, and we believe the case law does not require compensation for that. What it does require is the agreement of someone with superior knowledge to guide the person with
That would
lesser
be
knowledge.
every time I ask my friend, the stockbroker, for advice, then he becomes my fiduciary. And we have rejected that uniformly, that if I ask someone for advice and they give me advice, that person becomes my fiduciary. That's not the way we have rejected that sort of claim constantly. And here you even have an added layer of contracts that disclaim any higher duty of care.
Okay, the foreign exchange agreement has no fiduciary duty language in it, and the checking account agreement, that provision was limited to the checking account business.
What did McCorkle get out of this relationship?
I'm sorry.
Why did McCorkle get out of this relationship? You say he's a fiduciary. What was in it for him?
Oh, they were servicing a valued client. And we have testimony in the record that says that letters of credit are a profit-making.
Otherwise was not a fiduciary relationship.
That's correct.
So they volunteered to do some extra things for you.
And right.
That turned them into fiduciaries.
And we have plenty of case law in our briefing that says you can start with a contract that does not have a fiduciary duty, but then the relationship can evolve and expand into a fiduciary duty.
Because they gave you some unpaid advice, that's what expanded it.
But once you take the duty to speak, you have to actually follow on that duty, understanding that the negligent misrepresentation claim has a lesser duty, but nonetheless, when you have...
Maybe you have a duty to speak correctly, and that brings you to the negligent misrepresentation, but that for this relationship in which you're getting nothing out of it, that you get turned into a fiduciary when you voluntarily help out.
But when you write to someone who doesn't understand the process and says,
okay, let me start with that. The agreement, the FS agreement says it is between two parties who are experienced. Your client represented that. So when you're here saying he didn't know what he was doing, that's not what he said in his agreement. So it says, the irrelevant agreement, it's between two parties who are experienced in sophisticated and complex matters similar to the transactions, activities, and contemplated that is foreign exchange transactions, and it would be construed in a fair and impartial manner without regard to which party's bargaining power and everything else. So your client expressly disclaimed what you are saying now is the basis for your fiduciary claim. Maybe we should move to the negligent misrep.
Well, he's out of time. Do you have another question?
No, I mean...
Okay,
right.
thank you.
Okay.
You'll have rebuttal time.
Okay.
We were just letting you as...
Right.
May it please, may it please the court, Brian Yates on behalf of the respondent and cross appellant Regions Bank. Your Honor's hit the nail exactly on the head. There is no...
You seem to be doing pretty well on the fiduciary duty, so why don't you address the negligent misrepresentation?
Happy to do so, Judge. You referred to a negligent misrepresentation claim. That's not what was pled in this case. What was pled in this case was a negligence claim based on Regions' failure to conduct a proper suitability investigation of a letter of credit issuer, Salil Chartered Bank, and to discover public record what is alleged as red flags.
Well, wait, but the guy says to him, there is in the pleading, and he says to me, no, this is a good bank, no problem, no worries, go for it, right? That's the pleading. It may not be pristine, but it is clear that what the plaintiff is alleging here is that this bank person told me that the transaction bank was okay to issue the LC, right?
Well, what the letter of credit officer said was this bank is good, referring to the fact that it passed an OFAC check.
Okay, and it turns out that that bank didn't honor the LC. So, we're, in a notice pleading state like this, there might be 100 reasons why after discovery and everything else that doesn't pan out. But we're talking about the allegations of the complaint.
Well, we're here on summary judgment.
Oh, I'm sorry.
And the fact
I'm
is,
sorry.
there is no evidence
right.
that there is simply no evidence that Regions misrepresented anything.
Doesn't Strickland tell McCorkle that they're a shady bank, and McCorkle disregards that?
Well, he did not disregard it, but that brings me to what this case has become, which is negligent misrepresentation based on concealment. What the plaintiff has argued in response to summary judgment is forget the red flags. Never mind the public record red flag information, but we have an email from Mr. Strickland. What they've argued is Strickland requested, or McCorkle requested, that Strickland conduct a suitability investigation of the issuer, that Strickland, in a 2-minute Google search from his phone, conducted it and determined Salil to be a quote-unquote shady bank.
Is your position...
Go ahead.
Is your position that this was publicly available information, so therefore Mr. McCorkle, or rather Mr. Shapiro, could have found it anyway without Ms. McCorkle's representations, even though he was seeking advice from him?
Well, the public record red flags were certainly publicly available. The claim of concealment is based on Strickland's email, but email was an opinion. It's not a statement to have a claim predicated on concealment, which is what this claim has morphed into. It's got to have a misstatement of material
McCorkle and
fact.
Regions did undertake to provide some sort of advice here, didn't they?
I'm sorry, Your Honor?
McCorkle and Regions did undertake to provide some sort of advice here, did they not? I mean, okay, there's no fiduciary duty, let's say, but to the extent that they're answering his questions and checking up on it, didn't they have some obligation to see that they were giving him correct information?
Regions undertook to accommodate a standby letter of credit in ERA's favor, that they were willing to confirm it if ERA could satisfy certain conditions, and ultimately they advised
Separate
it.
and apart from the advising, it's undisputed based on this record that they did come to your bank for some advice about letters of credit, that they were not knowledgeable, that the bank did do some investigation, the bank did find out some negative information, and the bank did not impart that information to the plaintiff. Why isn't that enough, those facts, which are fairly undisputed, to create a claim for negligent representation that should go forward?
Well, no, because first of all,
What's wrong with that line that I just stated?
We'll accept that they undertook a duty to guide, to advise, if you will.
And they found some
purposes of
negative
this-
information, and then they never passed it on.
They did not find negative information because you have an opinion. That's not enough for concealment. You have
Isn't
to have
that
a
a disputed
misstatement.
issue of fact, whether or not it's a sufficient?
We don't have to go there, Judge, because the reality and the issue on summary judgment is ERA does not have an expert witness. There is no expert testimony
Why do
to
you
the
need an
standard of care.
expert for this type? I mean, why can't a court make these kind of determinations as to what's material, what's not material, and what would rise to the level sufficient to be a negligent misrepresentation?
How do you determine whether and to what extent a bank is suitable to issue a letter of credit? ERA is
Well,
admitted in their
if
pleadings.
someone on Regions staff who's working on this knows that it's a shady letter of credit, don't you think that it's possible to say that Regions had an obligation to pass that on to the plaintiff?
No, because no one on Region staff, quote unquote, knew
But
that
didn't Mr. McCorkle have his reservations? This seemed like a shady bank. Let me do a background check, and then came back and said, don't worry, it's all good. But isn't that what happened?
The only background check that McCorkle referred to was an OFAC check, which Solil passed. There was no issue there. The question to Mr. Strickland, what led to this email exchange, first, was a question as to whether Strickland was familiar with a customer on an unrelated request for a letter of credit, a customer that had an account balance of $1,100 used for Ubers and Walgreens charges, and McCorkle is looking at this saying, I don't understand why this customer is suddenly receiving a letter of credit. Strickland responded that no, he had never heard of the customer, but in 2 minutes did a Google search, pulled up the landing page of a website, and they say determined he had an opinion that, oh, this bank seems shady. But the fact is, none of this changes the fact that there's nothing in the record to address what the standard of care is as to the suitability or lack thereof of an issuing bank. This is not a readily apparent case of a doctor amputated the wrong leg or a dentist extracted the wrong tooth.
Okay, you have time for rebuttal.
Very well, thank you.
So can I ask you, how do you address the issue of expert? Like what information is required to be imparted when someone says to someone else, what do you think of this LC bank?
Right. So the cases that the bank cites about experts are cases like, my office manager stole 100 checks and you negotiated them. Is that negligent? And then you have an expert say, well, this is how a bank should watch out for that. Our case is bespoke. There is no other case like this apparently reported. Here you have the direct agreement that you'll check this bank. McCorkle writes, we'll do a quick background check, and comes back and says, this bank is good. I would have preferred Standard Chartered Bank. There's no disagreement. Standard Chartered Bank is a huge international bank, would be actually a good issuer.
So where's the misrepresentation?
The misrepresentation is that 5 days before that, Mr. Strickland, 20-year employee, wrote to him and said, this Soleil seems kind of shady. They just issue LCs because they're on SWIFT, according to their website. And the day after, or a few days after that, I'll check on Soleil, Strickland comes back a second time to McCorkle and says, I hope this transaction went away, and forwards a trade publication article about Soleil being sued for letter of credit fraud related claims. And then Regions issues its advising letter the next day.
Thank you.
Thank you.
Counsel, if I may, now, with respect to the negligent misrepresentation claim, we also have testimony from Sharippa that he was regularly questioning the bank regarding the first letter of credit because he wanted to be bulletproof, right? But then when we get to the second, he said he only accepted the second line of credit because the bank said it was good.
There were no communications regarding the second letter of credit other than you're going to receive a letter of credit that has already been issued. Please let me know when you get it. That is it for the $1.8 million letter of credit, which is what we're being sued upon.
So there was no representation to say, oh yeah, it's good.
No representations, no discussions of due diligence. And regarding the standard of care where you have...
Are you saying you have there was no damages because the letter of credit that was turned out to be not, you know what I'm saying, it wasn't, they didn't honor it, was what their damages are, and with respect to that one, there was no representations?
There were no representations by Regions other than here's the letter of credit that we received on your behalf.
So you're saying there's no damages with respect to that one, but the first letter of credit was the one where the plaintiff asked for the information, correct?
The first letter of credit is where the discussions about due diligence came in. That letter of credit was never drawn upon.
But is their point that they wouldn't have accepted the second letter of credit if they hadn't gotten your okay on the first? Isn't their case that we wouldn't have accepted the second letter of credit if we hadn't gotten your okay on the first letter of credit?
That's the claim, but the second letter of credit was double the amount of the first letter of credit. So,
I mean, I know you say you had no obligation, and if you did, you fulfilled your obligation. But if you didn't on the first, then they would have a basis to claim on the second.
I don't agree with that because you had two different letters of credit in very different amounts, one double the first. And going back to the expert issue, the standard of care where we're talking about a professional, where we're talking about a sophisticated institutional, a letter of credit, it's a professional negligence standard of care. It requires a community, it's a standard of care in the community. Again, there's no expert.
Thank you.
Thank you. Nice job.
That's all? Turned up?